In this series, my team of experts and I will walk you through every step of the surrogacy journey, from your first application all the way through birth and recovery. Over the past 5 years, we've helped hundreds of women through their own surrogacy journeys, and countless intended parents reach their dream of parenthood. Surrogacy is my life's passion. It's one of the most selfless and life-changing gifts a woman can offer another family. But it's also complex and emotional. That's why we've created this series, to educate, empower, and help you feel confident in each phase of the journey here at Alcea. Whether this is your first journey or not, there's so much to learn, and we're here to support you every step of the way. This video covers contracts, legal, and pre-birth orders. So congratulations. You have been medically cleared by your intended parents' IVF clinic, and we now have permission to begin the legal contract between you and your intended parent. Today we have Madison, who is our legal administrator, who's going to walk you through the details, the importance, and the specifics of the legal clearance process throughout your surrogacy journey.
Hi, my name is Madison. I am the Director of Legal Services and Community Outreach for Alcea. I work alongside the rest of our team to really facilitate the legal process end to end, not just your contract, but also parentage, whether that might mean a pre-birth order, a post-birth order, or both. So I will be there from the point that you are matched all the way through your journey, kind of behind the scenes, just to help things alongside your case manager.
I'd like to just insert one thing real quickly here. One of the reasons that Alcea decided to create a legal administration team is because in our industry, it's a conflict of interest to have in-house legal, meaning an Alcea employee represents either the surrogate or the intended parent. In fact, in the state of New York, we couldn't be licensed if we were working in that way. So our legal administration team is really here to make it feel like you have in-house counsel without the conflict of interest. It should still feel seamless. You still have a point of contact, but you don't have that extra layer of complexity that you're being represented by someone who is also your agency. So our way of doing this is protective for both intended parents and surrogates. And we've kind of found a way to make it feel seamless to you without entering into a complexity of a conflict of interest.
So the very first step on your journey, once you're officially matched and once you've made it through your medical screening, it's going to be finding and engaging the right partner for that legal contract. I'll reach out to you, I'll connect with you to see if you already have an attorney in mind to represent you. But if you don't, then we'll have a little bit of a conversation to figure out who might be the right fit. Maybe you're looking for someone who has a larger team. Maybe you're looking for someone who has just one paralegal and that's really it. You might be looking for someone who is especially timely, or you might have someone in mind that has just done this for years and years and years. We'll have a conversation, we'll figure out what is most important for you, and then I'll send you over a few names of people who can really fit the bill. From there, if none of those people feel like the right fit, I'll send you more names. And we'll go through that process until you find the right person for you. I do the same thing on the other side with the intended parents. And once everyone has engaged the right partner, then we proceed with drafting and getting that legal contract going.
So when you provide those names to intended parents and surrogates, I assume they have an opportunity to email or maybe engage in a phone call so that they can really determine if that's the right kind of personality fit and someone they can see themselves feeling safe with during this phase.
Yes, we will facilitate a direct introduction, and you can meet with all of the attorneys, you can meet with just one. Again, if no one on the list feels right, you don't have to meet with any of them. I will make sure that you feel comfortable with that person.
One thing I get as a regular question specifically from intended parents is, because we don't have in-house counsel, does that mean that they're going to be responsible for providing demographics and match terms and all the information to the attorneys? Or is that something that we handle here at Alcea? Talk a little bit about how those two attorneys that are ultimately retained work with the clients and therefore us.
Well, I think that's the biggest concern, right? There are so many moving pieces when it comes to legal. There's so much that goes into a contract. There's so much that goes into parentage. And the good news is that you actually don't have to worry about that. So I will send over the full package of information, everything that your attorney and that the intended parent's attorney needs to draft that contract, to review, and to enter into any red lines will come from me. So I'll send over compensation, I'll send over demographic information, insurance information, escrow information, a number of policies that also are with Alcea and with our applicable state licensure too, to ensure that your contract is ethical, to ensure that it is fair, and to ensure that it addresses every single thing that might come up on your journey, good or bad. Yeah. So I provide all of that information on your behalf.
And that really sparked something for me. You know, our surrogates at the very beginning of their pre-match process put together their compensation acknowledgement. And that's when they're going to make their determinations about their base compensation, maybe other fees that they are asking for. They then sign that, and that is presented to the intended parent with their profile. The way that Alcea works, and the reason that we have them do that so early in the process, is to make a guarantee that when you get to contracts, the numbers that the intended parents agreed to in matching, they will not ask their attorney to come down on that compensation. Yeah. But on the flip of that, the surrogate's not going to ask more of their intended parents than they asked for on that ROE and their compensation acknowledgement originally. So Absolutely. Everyone heads into it with an effort of good faith that we're all on the same page about what that means. Yeah. And we reiterate that not only in the pre-match, but then when they meet their case manager and have that rules of engagement call, you go through that to confirm so that by the time you get to legal, it should feel relatively seamless. Yes. You've talked about the big items multiple times to confirm that you're on the same page. And now it's a lot about legal ease and back and forth. Yeah. You know, I would love as someone that, you know, is regularly engaged with the attorneys. We hear our surrogates say this is often the most laborious and boring part of the process.
And it is.
It's cold, it's sterile, it
feels distant.
Yeah. And it's this personal process that's, you know, boiled down to this little document that has a lot of words that don't necessarily feel good. Yeah. So maybe you could add a little context on, you know, why are these agreements so critical to both parties? Why do they feel a little bit sterile and cold? And how can we support both our intended parents and surrogates to kind of see the forest through the trees about how ultimately it's necessary and that yucky feeling will go away?
So I think we've been talking kind of abstractly about what an agreement actually is. What we're referring to is your gestational surrogacy agreement. Now, your attorney might call it a GSA, your attorney might call it a GCA, or just a surrogacy agreement. That all means the same thing. It just really depends on the counsel that you've engaged. At the agency, we tend to say GSA, most likely. So in that contract, it does feel like a lot. It does feel like you have so much magic in that initial match meeting, and you're so excited. You've just made it through medical screening.
It's personal.
It's
and
then you
focused.
Get this massive contract. And I do think a big part of that is the length. And I do get a lot of questions. Why does this have to be so long? Why can't we just say, we'll do right by each other and we'll keep it moving? The biggest piece is that your contract has to address every single possible scenario. It has to address the good, it has to address the bad, and it has to address the uncertain. So we have to be able to attack every single stage of your surrogacy journey. So it will have all of the numbers. It will have your base comp and your fees, your bonuses. It will have lost wages. It will have all kinds of fees that you have seen and agreed to in your compensation acknowledgement. But it's also going to have a lot of supporting language about health insurance, language about life insurance. It's going to have language about diet sometimes, depending on, you know, your intended parents and you
and what you've agreed to
and what's most important to you. Yeah. If you have an intended parent who is saying, you know, I really, really want my surrogate to have an organic diet. Well, that's great, but that's going to need a lot of clarifying language. You would be owed a fee for that because that's going to be more expensive. And there's also going to be language about reasonable requests. So there's going to be a lot of what we call legalese to support even a small or a seemingly simple request. It's why that contract is so long, and it's why it feels like a little bit too much, but it really is intended to protect both you and your intended parent, and it's important. And it's why having an engaged and the right partner is going to be so crucial, because your attorney is going to be your advocate. Your attorney is going to go through that entire contract, add in additional language that might be necessary to support you and to protect you. Your attorney is going to review that contract with you so that you have a good understanding of what that language is saying, what it is intending, and also be able to discuss what might need to be changed. There might be language that your intended parent attorney adds in, and it may feel a little uncomfortable. There might be something that you want to tweak, or you want to add another clarifying sentence. Your attorney will do that. The length of the contract, the thoroughness of it, it's necessary, but it's not going to be made without your input. And it's not going to be made without you having a strong advocate on your side, not just in your attorney, but also in Alcea too. Compensation is a really huge part of the GCA surrogacy agreement. Compensation is really intended to start after you are confirmed pregnant. So what will happen is once that embryo transfer, let's say it's successful, and we get a true confirmation of pregnancy, that is when your base compensation will kick in. Now, you're not going to be paid out all at once. You'll be paid out typically monthly. It's usually broken into 8 or 9 disbursements, just depending on the contract that's written. And you'll be paid out in accordance with every single monthly milestone.
So on top of the base compensation that Madison just discussed, you also get bonus extras on top of your package. And the amount and the frequency can vary by agency, but holistically, the industry is kind of set what is standard.
Yeah.
So here at Alcea, you'll get your first bonus when you complete your medical screening. Your second bonus is going to come when you've signed your legal agreement. Your next bonus is going to come when you start your injectable medications. The next bonus comes when you attend your transfer. So even in an attempt to get pregnant, you're gonna see between $5,000 and $6,000 just for the time and wear and tear on your body and all the really intrusive processes that we've gotten through to get you to that point. So all of those extras are paid out until the surrogacy compensation begins, hopefully when you get pregnant, and then those are distributed equally. Once you're pregnant, there are also a few other things that you might see. So things like maternity clothes. If there's an invasive procedure, that's baked into your contract that in the event you had an invasive procedure, you would get paid. In the event you had an embryo split and you end up pregnant with twins, there'll be a what if payment that the baby is, you get paid X number for one baby and X number for two, because the intention was not for you to carry twins. There is typically an extras fee for something like a C-section if you've never had a C-section before. So you also have your extras that are pretty standard that are paid over and above the base compensation for all of the little things that happen along the way. And again, the reason for that is that these contracts are to represent that we're never paying for a baby, we're paying for the process, the wear and tear on the body, the time away from the family. All of these things are established to ensure the surrogate feels well compensated for the piece of the process that she is undergoing at that time, and she does get some form of compensation, agnostic of whether she ever truly achieves a pregnancy on behalf of her intended parents.
Yes, and we're going to be, again, in constant communication with the escrow company to make sure that these are being dispersed accordingly. So we'll be reaching out to them to let them know, hey, we've got heartbeat confirmation. We'll let them know, hey, there was a split. There's twins all of a sudden. So we'll be connecting with them consistently and throughout your journey for anything that might come up, anything that might impact those disbursements. If there is, something that wasn't dispersed, we're gonna make sure that that gets to you ASAP. So we're going to be connecting with the escrow company to ensure all of these disbursements, all of these extras, these bonuses are getting to you in a timely manner.
At Alcea, surrogates are able to establish their own base compensation. We do give first-time surrogates a parameter of typically $50,000 to $65,000 and say that that's pretty much market standard right now. That's not to say a surrogate can't go below or above that. What we would say if a surrogate wants to go especially considerably higher than that, there might be a longer wait for her to match, and we might not be able to find intended parents willing to pay over and above such a higher amount of market standard. Second-time surrogates, we give no real parameter. We allow them to tell us what surrogacy means to their family, considering that they've experienced it before. Right now, our extras package is kind of set. It's the set amount that we say, this is what we tell all intended parents. But in the current climate, we are hearing more and more that surrogates want a little bit more autonomy in setting some of those extra fees. So as of right now, we're actually moving to ranges so that surrogates can look at what's the most important part of that extras package. And they'll also be determining that early, but it won't be something that the agency determines for them. We'll give them some acceptable ranges, and then they can pick which of those extras are more applicable to them or more important to them. So holistically, the surrogate is the one that has full autonomy to determine how much compensation their family feels is necessary to make this process worthwhile for them.
So we talked a little bit about how I send over this full package of information on your behalf and on the intended parent's behalf. When I send that over, I send it to both your counsel and to the intended parent's attorney. That way, everybody is working with the same amount of information to build this contract. As a baseline. The intended parent attorney, they will draft. They will start that first draft. What I tend to tell clients is to bank around 6 weeks for legal. A big piece of that time is that very first draft, which is the most frustrating time, because then you really are just waiting. You really are just waiting to see that very first draft of what your contract could look like, because maybe it takes a couple of weeks. Maybe it takes a full 3 weeks. But what we're looking for is for that to take around a week, week and a half, to get that over, for the intended parent's attorney to actually draft that contract, and then to schedule some time to review with the intended parents, and then to get that over to your counsel. Behind the scenes, I'm also gonna do an immediate review of that first draft, just to ensure that that contract is in line with the match terms that I've presented. Again, your compensation should not move. It shouldn't be different.
The policies and procedures that we have in place to protect you,
Yes.
minimums for escrow,
That should not
timing
move.
of payment, that shouldn't move.
I say to our clients, you should not be surprised. You shouldn't be taken aback by the language that you're seeing. You shouldn't be disgruntled by what your compensation says. There should be no surprises on that end. So I take a second, I do an initial review, and once I give the go-ahead, and once the intended parents have also given that go-ahead as well, then their attorney will typically send that right over to your attorney. Your attorney will take that contract and they'll schedule an initial review with you. Now that can be a long one. I'm not gonna, that could be a really long review. It can take a couple of hours to get through an entire contract, to go into the language, to explain anything that may not make sense. Again, this is all legalese, it's all contract language. It's not easy.
Not to interrupt, but we also want to make sure that the surrogate understands each and every element so that later on there is never an ability to say that she was coerced or did not understand what she was getting into.
The biggest piece is informed consent.
It's so very important to us that, ethically speaking, there are no questions left on the table, and that there isn't a later surprise when she's pregnant and no longer unable to be a surrogate.
And that's why, while you will always have access to your case manager, when it comes to the legal process, I also will make myself available if we need to have a larger discussion. My phone number is in my signature line. We can put some time down because it's a lot. And the biggest piece is that you are informed and you are supported, and you're not just signing on the dotted line just because you just want to get to the next stage. We have to be sure that not only is the language protective, not only is the language exactly what it should be, but also that you have a good understanding of the intentions behind that language. And that's why that initial review will be so long.
Yeah, and like, for example, there will be restrictions around travel towards the end of your pregnancy and not being able to leave a certain amount of miles from your state at a certain point in the pregnancy. It's possible that you want to put in some language that in the event of an emergency that doesn't apply, or other things. And so there are things about this process end to end that are so what if. Your attorney almost has an obligation to make sure that there isn't anything that you're going to feel on later like, dang, I really wish I would have put that in the contract, or I wish I would have known. Because once it's signed, and that is the terms, and everything will go from there. Everything for your escrow decisions, when we say what's the decision, we're going to go to the contract and say, well, what does the contract say our decision is?
Your GSA will define the rest of your journey, and it will have exactly what Angela is speaking to, but it'll also have things that to you you're like, yeah, duh. It'll say don't take drugs, don't drink alcohol, don't get a tattoo or a piercing. Things like that will seem maybe a little bit silly when you read it and you're thinking to yourself, why does that have to be in an actual contract? But it's still important.
Right.
And again, it's why that contract is long. It is going to address every single piece and every single potential piece of your journey. Now, I will say, if there is ambiguity, if there's some sort of vague language, if something's just not quite making sense with your GSA once it is signed, then I will still work with your attorneys after you are legally cleared, if there is a need for an amendment or an addendum or something to clarify any sort of language, if there is something that just wasn't quite right.
Or changes in a situation.
Or changed in a situation, exactly.
A job change and now you need a higher lost wage or something's changing.
Yes.
Our job is to advocate for that.
We will engage counsel. We will discuss what has changed. And your job will just be to continue to connect with your advocate, connect with your attorney, answer their questions, answer what is most important to you when it comes to these changes. Get the notary signed. We'll be there every single step of the way, but it's not on you to facilitate that process. It will still be on us.
The process of the legal agreement, I think sometimes feels like a black hole because really what it is the gestational carrier waiting for the initial draft, then the gestational carrier waiting for the attorney, their own attorney, to set time up to go through the draft, and then you've got to wait to make another appointment with the next back with the IP attorney to go through all of those questions. And if you have 30 or 40 red lines on a contract and you've got to go back and forth on all of those, that stuff takes time. And it also sometimes takes time just between the attorneys. They're working out the legalese and not necessarily engaging the client. It could be an issue where they need to ask the intended parent a question and the intended parent is out of pocket for a couple of weeks. And last thing as we close the loop, I think that it's really important for everybody, both intended parents and surrogates, to remember sometimes the answer or the way that you're getting a response is purely based on how the attorney chose to word it. And what I mean by that is we've had a lot of surrogates say, how could my intended parent say XYZ? And I read that sentence and I know no intended parent said that. That was an attorney language using that. And sometimes people already begin to form this idea about communication. Do not do that during the contract process. It's meant to be sterile so that when it's over, it's over.
You just flag something that I actually get a lot of questions about. And it's specifically when you see language that is particularly concerning and you're wondering if this is coming from your intended parent or counsel. There's a couple of things that I want to address here. Number one, the attorneys are drafting, just like Angela said. The attorneys are the ones making all of this language. 9 times out of 10, it's counsel. But also, these attorneys are influenced by their own experience. They might have some particularly harsh language because of one problem case that they saw 10 years ago. That doesn't necessarily mean that your intended parents are, especially moved by this one piece. It doesn't mean that they are digging their heels in on that one piece. It is often counsel. Another part of my role is to iron out the wrinkles during the legal process. If there is something that's coming up with counsel, I've had plenty of clients who have come to me and said, Madison, there is just one piece that we cannot get past. Her attorney can't get past it. Our attorney can't get past it. Have you seen anything that could go here that has worked before? And I don't even want to say 9 times out of 10, 10 times out of 10. The answer is yes. I have seen language that resolves both sides' issues. It's language that is always simple. It's always something that is quickly inserted, and I'm happy to send it over to the attorneys. If there is an issue with counsel and their communication, then I'll step in there as well. The biggest part is that we don't want you to feel the brunt of any disconnect amongst the attorneys or any sort of disconnect just on the legalese, because again, legalese is harsh.
We want you to have full informed consent on every piece of this process before you make the commitment. And once you've signed that legal agreement, it's a legal agreement, and you're bound to those terms. And so we want to make sure that those terms are fair and equitable and ethical for everyone. Now, I know that, obviously people think that the contract, and there's truth to it, the bulk of that contract is going to define the compensation exchanged, the monies that would be due at what time, the necessary funding of escrow, et cetera. But that's actually only a small portion of the gestational carrier agreement. Obviously, it also addresses any kind of lifestyle or behavior expectations. There is usually a celibacy clause that's based on your clinic's requirement of how long you need to stay celibate around the time of transfer. It says, what would happen in the event of bed rest and how much you would be compensated. It says that the surrogate has a mandatory, need to follow medical directives. It kind of just defines obligations. But in addition, it also acts as a protective document in a couple of other ways. It's going to be written almost always by the law in the state in which the surrogate lives. And that is what drives the intended parent's parentage. We hear on both sides, what if the surrogate changes their mind? Or what if the intended parents change their mind about being a parent? This is where the gestational carrier agreement is so very important. It's going to define how the surrogate state handles a surrogacy agreement. Do you get a pre-birth order? Do you get a post-birth order? What is the process, or both? Exactly. What is the process by which that has to happen, and who is responsible for what piece of that? So the language in that contract is also what's going to solidify the fact that a surrogate can't legally change her mind, and nor can an intended parent. And it will go so far as to also say, in the event something happens to the intended parent throughout the journey, there are basically two people named. One person that will help with the distribution of funds to ensure that the surrogate is still paid. And then the second is someone that will help take custody of that child physically, a guardian. And so this protects surrogates for the what ifs of, all of those things that could potentially happen, albeit rare. That you're protected within that contract. Also, every state does things just a little bit differently. Absolutely. So having that law specifically there in front of you helps everybody to understand at a very specific level what people's responsibilities are to ensure that that pre-birth order is granted and that we have no issues with parentage either before or after the delivery.
And again, that is why having that attorney in that very first step is going to be so important. I will send you names if you don't already have someone in mind, because the biggest thing with Alcea is that you truly have choice of counsel. I am not intending to interfere. I am only intending to support. So if you don't have someone in mind, I'm going to send you names of attorneys who are licensed in your state. Those are going to be the attorneys that are ultimately going to define the applicable state law and exactly what Angela is speaking.
And that attorney is an expert on that state law. Exactly. And so, right now we're in an interesting political climate where we get a lot more questions than we did previously. Things like if I should be concerned if my surrogate lives in an abortion hostile state. Does the state have an actual statute, or has everything always been handled by case law? Meaning there's actually no law in the book saying surrogacy is illegal or legal. It's just been done and judges have said that we'll do it. And does a queer couple or a couple not biologically related to their embryos want to take a chance in a state where there's no real codified law? And so not only does this attorney work to be your advocate in the contract, they also help to make sure that we're not making matches in states that make this any more potentially problematic than it needs to be, and that it's protective as possible. So that's definitely something that this attorney as well as the agency work together to make sure that is addressed and explained to the surrogate and the intended parent. So once you get that signature and you have that notarized, you have official legal clearance, that's when we're going to move on to make sure that your intended parents fully fund escrow. The amount that they need to fully fund is actually in that gestational carrier agreement, so the surrogate knows that her
and it's a part of the match terms.
That's right.
Well.
So your full compensation as well as an extra buffer has to be in the escrow account before you can start any medications and move towards a transfer. And so this is a part of the process that can be lengthy, can feel a little bit like a black hole, but ultimately is one of the most important pieces and really does set all parties up for a safe and ethical surrogacy journey.
So escrow is going to be the neutral third party that is holding the funds for your journey and dispersing those funds accordingly. So initially, an intended parent will set up the escrow account with an initial deposit, and that will happen once you are officially matched. Once we've got confirmation of match, I'll have a meeting with both them and you separately, and then they'll go ahead and get that escrow set up. That's going to serve as a trigger for all of your next steps. Once that escrow is funded, that's when we're going to start booking medical screening. That's when we're going to start paying out for travel. All of those pieces are dependent on that initial escrow. At Alcea, escrow will always be held by a neutral third party. Our biggest policy is that escrow will not be held by your attorney or by your intended parent's attorney. For us, it's a conflict of interest. It means that they will still represent the best interests of your IPs, or your attorney will still represent the best interests of you. And the biggest thing is that these funds should be neutral. These are funds that are going to be defined and agreed to through your GSA and also in the agency agreement as well. And so it should not be politicized. It should not be...
There's not an opinion.
There's no bias. There's no opinion. Right. If there is an issue with the contract, if there's something that's being contested, then a neutral third party is going to either help resolve or look to the partners, the attorneys engaged, the agency, to resolve the issue. They're not looking to make a decision that benefits one side or the other just because they represent that person. So that initial deposit will happen into that escrow account, that neutral trust account that holds all of those funds. Once you're legally cleared and you have a GSA in place, as Angela mentioned, the intended parents are going to do a deposit of your entire compensation plus a buffer. And they're also going to have to maintain certain minimums in order to move through the rest of their journey. If they ever fall below those required minimums, I step in, their case manager steps in, other team members might step in just to ensure that they're funding the account appropriately and things are moving forward in the best way possible and in the way that's defined by your contract.
But ultimately, if intended parents choose to not fulfill their contractual obligations, we'll escalate to the escrow company first and then to the attorney so that we can protect you and make sure that the intended parents know that they are in breach of contract by not keeping their minimums. So we are on it and watching it to make sure that it is always available and funded to the level as it should be at the appropriate time. I think one other just quick thing about escrow that I think is, kind of an interesting thing here at Alcea, we try to keep the process for the surrogate as simple as possible. A lot of agencies ask their surrogates to directly submit bills and do different things to the escrow company directly. And if we have a surrogate that wants to do that, they can. But at Alcea, we have a bookkeeper who manages all of that, and the surrogate can just throw it her direction. She organizes it all, does the screenshots, and then she'll check to make sure from her lens it matches the contract, but we're ultimately not making the decision makers there. So then she sends it over to escrow, and then escrow will make the actual distribution. So it's also a way for surrogates to have a little bit better ease of process, and it's another layer of protection for intended parents to know there's actually two eyes on that, and if we know that a bill isn't applicable to surrogacy, we won't waste escrow's time by even having them make that decision. But that escrow company ultimately is staffed by people that are subject matter experts on surrogacy contracts, and they're going to look for every reimbursement and say, okay, what does this GSA say? How long does it have to be paid out? They're going to calendar all of those payments so that intended parents have a good expectation. But it's just a really good way to stay neutral and to make sure everybody gets paid on time and that there isn't anyone left without the compensation that they've earned.
But again, I will also still be directly involved there. If there's a question that you have also about, I think this is what the language is saying, I can give you, a good read, but I will also still engage the attorneys who are involved and who wrote the contract to ensure that what we're reading is correct. So if there's any sort of ambiguity, if there's some sort of vague language, then just like Angela said, we're going to engage the right people. We're going to bring in counsel. We're going to bring the escrow company. And we will do a lot of internal work to make sure that that issue is resolved so that, again, you are not feeling the brunt of any sort of disconnect. And if there's a need for an addendum or an amendment that clarifies that language, then we'll work to bridge that gap as well.
So then once you're legally cleared, you're going to move to embryo transfer and hopefully a successful pregnancy.
The fun part.
The fun part. You'll get released over to the OB, and then the next time that you see the legal administration team is going to be around parentage.
Yeah.
So we're going to talk to you a little bit about the pre-birth order and how that works.
So a pre-birth order is intended to establish parentage prior to the birth. It's often supported by a post-birth order, which will just do the same thing. It's further establishing parentage. To establish parentage, what we're saying is that the court is defining that these intended parents who are engaged on this journey are legally recognized as the parents of this child that's coming out of this surrogacy arrangement. More often than not, a pre-birth order is going to say, regarding baby last name and the matter of these intended parents who are going to be established as the parents themselves. So that pre-birth order is just going to be a legal court document that says you're not the parent.
I think the other thing to lend is, and I think this vernacular really became part of my regular speech when all of the laws changed here in New York. The Child Parent Security Act mentions so many times that the intention of the legal agreement is intention.
Yes.
And what I mean by that is whether or not it is, the sperm and the egg of the people that created the embryos and then that's being carried by the surrogate, whether it was a donor egg and one of the biological parents, whether it was a donor sperm and one of the biological parents, or even if it's both a donor sperm and a donor egg, none of that matters. The court is saying the intention of this agreement is that this baby was conceived and to be carried by this person for the intention of these people parenting.
Yes.
So intention is really what I always say is the biggest kind of reason
it absolutely
for
is. That's
that.
why we say intended parents.
That's right. It's protective and it's to establish intention.
Yeah.
So that the courts say all of the other stuff, biologically speaking, doesn't matter.
Yeah.
The intention of this agreement was for these people to parent this child.
Yeah, to put it another way, what is the spirit of this arrangement? What are we moving forward to do? And what we're trying to do and what we are doing is setting these intended parents up to be the parents of this child, never the surrogate.
And we're also telling the courts that we did not coerce the surrogate, that the surrogate was given fully informed consent, and that she was screened, and that has been deemed a safe surrogate. So really,
and that she has had the opportunity to negotiate her contract.
And so all of the things we've done today is to make this attestation and to sign on the dotted line to say, yes, everyone has crossed their T's, dotted their I's, and we are actually ready to move forward to make a baby together. I mentioned in a previous video, really when it comes to the parentage, the gestational surrogate's role is really pretty limited.
Yeah, just
it's
signing.
often a signature, occasionally maybe a Zoom appearance in court.
Very
rarely now.
Rarely.
But to be honest, that's typically always an intended parent focused process.
Yes.
They're the ones working to make sure that they have all of the legal documentation prepared. Their attorney's the one that will take the lead on that. And we will make sure that you know exactly what documentation you need to bring with you to the hospital so that when you get to the hospital, everyone will respect that pre-birth order. You have no legal responsibilities. You'll get that notarized copy, probably an extra copy as well. And we'll walk, through whatever your part of the process is. But really, logistically speaking, there's not a lot of action for you to take, but it's huge because what it does is alleviate that fear that you're ever going to have any kind of responsibility in the event, the parents change their mind, something happens. There's, again, in addition to that contract, you've got another set of parentage that is going to make that clear that the surrogate is in no way responsible for this child, despite whatever happens.
So maybe to get into the actual process as well. So once you are confirmed pregnant, my team, my admin alongside me, will go ahead and send that confirmation to the attorneys at that point. We'll check back in around the 14th week of pregnancy to ensure that the parentage process has at least been initiated. Now, depending on the state, parentage can vary really, really greatly. In some states like Illinois, parentage is just an administrative process. It's not something that would start at the 14th week. They usually start that much, much later because it's as simple as filling out some forms, some certificates, and then the intended parents are added to the birth certificate, and it's the simplest process, I think, by far. In other states, we do have to get started around the 14th week just to be sure that we're navigating the potential wait times of the court. So what we'll do is around the 14th week mark, we'll check in with counsel and see if they need any additional information on our end to help facilitate that process. So if there's a need for another attorney to be engaged on your journey when it comes to the parentage process, then we'll ensure that part of the process is also done. So let's say your intended parents are in New York and you're in North Carolina. You already have your North Carolina attorney as a result of the GSA. That same attorney can provide you with representation and can still be your advocate through the parentage process. In fact, your attorney will most likely be the person handling parentage just as a whole. They will likely be the ones to draft any sort of pleadings, to file anything with the court, and to pass around, the final copies that everyone is going to be looking for to provide to the hospital, but also to keep for their own records.
But in North Carolina, they also require that the intended parent have a North Carolina attorney.
Exactly. So what we'll be doing is we'll work with the intended parents to get a North Carolina attorney. That same process that we started this with is sending over those few names, addressing what is most important. I'm going to repeat that all over again on the other side. If they want an attorney with a big team, a small team, we will make that happen.
I will say that isn't a ton of states, but there are a few states that do require that both the intended parent and the surrogate have separate counsel in that state to grant parentage. And so we're familiar with that. And in the event that that is necessary, we help to facilitate and make sure.
Yeah, but again, it's not a part that a surrogate is going to feel.
This part is really simple.
You will not even know that this is happening internally. This will really just be up to us and to the intended parents. So once we've got an attorney set up for them, then both of those attorneys are going to work together to get parentage resolved. So I'll send over to that new attorney the GSA that you already entered into. I'll send over some demographic information, that same match sheet and match terms that I sent over previously for the contract, just to ensure that all the attorneys have everything they need to get parentage across the finish line. Your attorney, again, will draft those pleadings. They'll file those with the courts. For most attorneys, they've got really, really excellent relationships with the judges. So they know exactly who they want to go to. They know when they need to go to them. And the actual process is so, so smooth. When we have that final order, that pre-birth order, we keep that. You usually get that quite early. We're not gonna be getting that a week before you're due.
And you try to get it, close to point of viability so that if the baby's born early, there's no issues.
Exactly. So we'll already have that in our records by the time it comes around for your due date. And prior to your delivery, we'll go ahead and connect with the hospital directly. We'll provide them a full package of information so that they are prepared for what this delivery is going to be and for a surrogacy delivery as a whole. So for that package, it'll still be your GSA, it'll be your birth plan that you've gone through with the intended parents, it'll be parentage, it'll be any insurance information. We do all of this on your behalf so that you don't have to feel any part of this. Afterwards, in some states, there might be a need for a post-birth order. As part of our process, we send over all of the delivery details to the attorneys just in case. If there is a need for a post-birth order, then the attorneys have all of that information and they know to get to work on that ASAP. So we'll send over the time of the delivery, the name, the length, the weight, everything that they could possibly need in order to file that post-birth order. That is usually even simpler because it's truly just filing with the court, and then once you've got it, it's good. And that's really it. You're not going to feel that parentage process outside of a signature, outside of, us getting you a notary so that you can get that done. You might be asked to provide some additional information, but that's really it. And the beautiful part, I think, of all of this is that you just get to focus on the happy part. Right. You get to focus on helping someone build a family. That's the special part. That's what we want to preserve. And let us do all of the internal work.
And I will say, in closing of all of the legal process that does sometimes feel so sterile and yucky, I know one thing that surrogates often ask is is my name going to be on the birth certificate? Mm-hmm. And I always remind every intended parent and every surrogate, no matter what state you live in, if you are in a state where for some part of the administrative process, the surrogate and or her partner's name is on the birth certificate, when parentage is complete, whether that's pre or post, that is redacted forever, and that is not some kind of public record out there. Absolutely. That you were a surrogate. That is not a birth certificate that exists in actuality anywhere. Legally speaking, it's an administrative process because of the way that they, track vital statistics and do other things. But in the event that there is a need to have, even for a short time, your name on the birth certificate, there is never in any state a long-term reason that you have any legal or financial responsibility for the child that you give birth to as a gestational surrogate. Yes. That's actually one of the reasons so many people choose surrogacy, gestationally specifically, over traditional or adoption, because there are so many more protections. No one can just change their mind like they can in certain situations.
Because you do have to think about everything that we have done so far that has specifically said, you are not the parent.
Right.
Your GSA will say that, your pre-birth order will say that, and if you need one, your post-birth order will say that as well.
Yeah, and you make attestations to that.
Exactly. Mm-hmm. And so every single legal document that defines this journey, that defines the arrangement, that defines the relationship, will say that you are not the parent, and that the people who are engaged, the intended parents, the intentions of these legal documents are to say that this is the parent. I think the big win for the surrogate, when she signs that contract, after all of the time that has been invested, after all of the energy that's been invested, the time of scheduling, all of that, getting to sign on the dotted line and getting to say, okay, we're doing this thing together.
We are now contractually obligated to what we've been talking about for months upon months.
But also that we're clearly both the same. We have the same level of investment.
Yeah,
we
all
did
in.
this together. We made it to the end together. I think there's something really powerful about being willing to sit through 6 weeks of negotiations and looking through red lines and talking to attorneys on top of your screenings, on top of everything else, to get to a point where you say, okay, great, now let's go build a family. I think there's something really lovely on both sides to invest that time, that energy, and that trust in the process so that you can work together and do this incredible, insane thing that is not typically done from strangers.
And now you're protected and safe, and you can move forward without this hanging over your head.
Exactly, yeah.
Thanks so much for watching, and please consider subscribing. In the next video, we'll cover everything you need to know about starting IVF medications, preparing for embryo transfer, and then pregnancy.